Hello again, ladies and gentlemen. This is Brian McClanahan, and today we're going to talk about the Marshall Court. And this is actually going to be a two-part presentation. I'm going to handle the first part in some of the major cases, and Dr. Goodsman is going to handle the second part. And of course, understanding the Marshall Court is key to understanding the modern interpretation of the Constitution. Now, John Marshall is not always followed, but even in the recent Supreme Court decision on the so-called Obamacare legislation, the Marshall Court was cited. So the Supreme Court does go back and look at his various rulings and on the court, and the way that Marshall, of course, was reorganizing the decision system was very important. But people do look at John Marshall. They still look to him for guidance, and this is why John Marshall, in addition to Alexander Hamilton, are the two most important men in American history. I mean, you can say George Washington, well, I say outside of George Washington, the two most important men in American history in terms of government. You know, Washington wins the American War for Independence. I mean, without Washington, we don't win. And also, as first president, really codifies how we're going to handle the executive branch. But without Hamilton and Marshall, we don't have this very broad nationalist perspective on the Constitution. In fact, one historian called this aggressive nationalism during the Marshall Court. So it's very important to understand John Marshall. And so we're going to look at a couple of his more important decisions in these first few years of the Supreme Court, and talk about how they later affected our view of the Supreme Court. I'm going to talk a little bit about John Marshall himself and how he actually came to the bench, and it's important to understand that too. So let's get started with John Marshall. Now, John Marshall, as I just mentioned, is the most important figure in American law. Hamilton is the most important figure in terms of economic policy, but Marshall is the guy when it comes to American law. Let me talk a little bit about Marshall. Marshall, of course, is from Virginia, and if you get my politically incorrect guide to the Founding Fathers, I actually have a chapter on John Marshall. And of course, Kevin Goodsman deals with him quite extensively as well in his book on James Madison and also on Virginia. It's important to know who John Marshall is, now where he comes from. So he's from Virginia. Marshall didn't really have a good reputation. He was always seen as a guy who's kind of disheveled, lazy. He dabbled in various things. He loved living in the big city of Richmond, quote unquote, the big city. His homespun frugality that he had going at that point just disappears, evaporates when he gets to Richmond. He went into debt. And so one of the reasons why he actually took a job in the federal government in the Adams administration is to make money, because he was broke. And Marshall, of course, served in the American War for Independence. And what the war is going to do for Marshall, what is something it doesn't do for many of the other members of the founding generation, it actually gives them this nationalist outlook. Hamilton the same way. A few of the guys in the American War for Independence that fought and served came out with this nationalist perspective, whereas many of them, take for example a lot of the Southerners, for example Francis Marion or Sumter or Pickens, people like that, John Rutledge in South Carolina, all these guys had a more, state outlook. And the same way with a lot of the members of the Army in different other states, even northern states, had a more state-centered outlook. Marshall, though, becomes a nationalist because of the war. And so that nationalist perspective is going to carry forward. Now, he serves actually in the Virginia Ratifying Convention of 1788, where he makes all kinds of statements about this Constitution. He doesn't speak many times, but and the times he does speak, it's just pretty meaty stuff. Unfortunately, no one ever focuses on these things, because if they did, they would see that how duplicitous John Marshall actually is. He's another liar like Alexander Hamilton. John Marshall stands up and says, you know what? We're probably going to have judicial review. All right, look. That's almost going to be a given. And actually, the opponents of the Constitution said, well, we hope so. We hope we have some backstop here, that the Supreme Court, these independent judges, are actually going to be worth their salt and say, Congress, you all are making stupid laws. They're unconstitutional. We got to do something about it. So in Virginia, they were saying, well, we hope so. But what Marshall said was very interesting. He said, well, look, we might declare federal law unconstitutional, but never state law. And that's very important. Never state law. Well, as we're going to see in this particular presentation, Marshall goes back on his word. And that was always the key to this entire court system, this judicial branch. You see, before we had the judicial branch, of course, the referee in any of the disputes between the states was the Congress itself. So by having the judicial branch, the idea was, well, if the states have a dispute, Virginia and Maryland have a dispute, well, we're going to have the Supreme Court there. So that that can be the final arbiter, the final referee, impartial referee. Well, it's never really been impartial. It's always been political. And the Supreme Court has generally done a pretty bad job over the years in abusing its authority in this way. And of course, the Congress could decide if there was going to be a larger federal court system, which they would give us with the Judiciary Act. The Congress could decide the appellate jurisdiction of the court. And what they didn't want to happen, what a lot of the founders didn't want to happen, was that the state law would be appealed directly to the Supreme Court. That was always the issue. So they didn't want the judicial system to destroy the state courts, which is essentially what happened. By establishing the federal court system the way that they did in 1789 with the Judiciary Act, and then the way Marshall conducted himself on the bench, they destroyed the state court system. The state courts are emasculated. They can't really do anything because ultimately if the Supreme Court or the federal court system wants to hear a case, they're going to hear it, and the state judges are just kind of kicked to the curb. Right? So the state judges become irrelevant. Now, there's times that, of course, the federal court system won't hear a case and it'll stop at the state courts, but anytime they want to, that's always out there. And that of course, can cause all kinds of problems. Now, Marshall's also admired by the modern left and the modern right. This is really, he's in a unique position. Same thing with Alexander Hamilton. A lot of people on the right like Hamilton. A lot of the big government conservatives that think we need an active, energetic government just in a different way than the left wants, and most importantly in terms of defense. They like people like Hamilton. They like people like Marshall. In fact, Russell Kirk was a huge fan of John Marshall and John Adams. But Russell Kirk made a very interesting statement at the end of the chapter in his very famous book, The Conservative Mind. He said, well, look, John Marshall looked at the federal court system as a way to destroy this liberal impulse coming out of the French Revolution. John Marshall called the Jeffersonians terrorists. He really believed in his mind that these Jeffersonians, these Democratic Republicans, these Jacobins, were going to try to have some type of French Revolution here in America, and he was going to use, by God, that court system to destroy it. That's what he wanted to do. And so Russell Kirk admires him for that, because he's trying to work against this liberal impulse. I think that, Marshall was psychotic in that way, that none of that stuff was ever going to happen. But Kirk admires him for that particular thing. But he also says, very interestingly, at the end of the chapter, John Marshall destroyed another type of conservatism, a Southern conservatism, which was Jeffersonian conservatism. He destroyed it. And that Jeffersonian conservatism is generally what libertarians are attracted to. Because that Jeffersonian conservatism, that Southern conservatism, is not John Marshall conservatism. And this is why people like Murray Rothbard could like John C. Calhoun. This is why people like Murray Rothbard could like the States' Rights Party of Strom Thurmond. Because essentially that's what they're doing. That's what they're saying. This is the Southern conservatism that they like. It's limited central authority. Now, of course, a lot of libertarians have a problem with the South, but in terms of slavery and race and things like that. But at the same time, they see what the South was pushing for here, this decentralized America, which would be more receptive to libertarian ideas. So this is why, libertarians love Southerners. And why not? Southerners are great. So, what he's also going to do is reorganize the decision system into the majority and minority opinion. And so this is the unanimous court. Marshall would often speak for the unanimous court when he would write his opinions. And that way it looked like there was no dissent. That didn't mean there was no dissent. Of course, you could have a minority opinion. But, Marshall, I think, was only in the minority one time in his entire time on the bench, which was 34 years. So what we're going to get out of John Marshall is 34 years of constitutional quote-unquote interpretation. And then, of course, his protege, Joseph Story, is going to write, as we'll look at when we look at the antebellum commentaries on that presentation, he's going to write a book on the Constitution that now everybody picks up and says, well, here it is, the definitive book. We're going to go get Joseph Story and Alexander Hamilton, and we're going to learn the Constitution. God help us. But that's what people do now. They go out there and get Joseph Story, Alexander Hamilton, and maybe a scattering of John Marshall in there, and so they're going to learn the Constitution. We're going to read the Federalist Papers, we're going to read Joseph's Story, and now we're going to know it. Yep. There's the downfall of everything. And so if you want to see, you want to look at it, well, here it is. This is why we've got Liberty Classroom. This is why we have great presentations like this, and what good work Dr. Guzman and Dr. Woods, Dr. Jewell and Dr. Herbner and all the great instructors here. This is why you're taking this stuff, so you can get the real scoop. But John Marshall's going to just screw everything up, and he's going to start very early on in his time on the bench. Now, the most important case, of course, is the Marbury v. Madison case, at least early on in the early process. Now, this involved three characters, and so I've given them to you here. The first and foremost is William Marbury, the jilted justice of the peace. Second, of course, the second actor in our extensive drama on Marbury v. Madison is John Marshall, the supreme savior, and also the lazy Secretary of State, because he's the one that forgot to deliver Marbury his appointment. So Marshall's in the center of this from the beginning. And then you've got James Madison, the sued secretary. So you've got the jilted justice, the supreme savior, and the sued secretary. So, here we go. We've got the three main characters, our protagonists in our great, drama, our great history story. And, just to give you a little background what happened. Well, when John Adams was president, you had the establishment, you had a federal law that allowed him to place a number of federal justices on the federal bench. Okay, and this is the quote unquote midnight judges. Now they weren't appointed, midnight the day before Adams leaves, but he's able to appoint a number of people, and William Marbury is one of these guys. Now he's going to be a justice of the peace in Washington D.C., so a insignificant federal court appointee. John Marshall was Secretary of State. Well, he's too lazy to deliver the sealed appointment to William Marbury by the time he leaves the office. So Marshall is then appointed Chief Justice of the Supreme Court. He goes on there. Well, Marbury's sealed appointment is just kind of laying around. Nobody's done anything with it. And then, of course, Jefferson wins the 1800 election. 1801, he comes into office, and James Madison is now the Secretary of State. And he and Jefferson get together and they find it's a sealed appointment. They say, well, screw it. We're not going to give that to Marbury. That's a way to get out of this stupid Federalist on the bench. We got to get rid of these people anyways. There's one down. We'll have to deliver his appointment. So Marbury's going to find out about it. He says, no. I was appointed. Just because I didn't get my appointment doesn't mean I'm not going to be on the bench. So give me my appointment. And if you don't give it to me, I'm going to sue you. He sues for a writ of mandamus, which meant that he could demand that his commission be delivered by the Jefferson administration. Now, this was allowed under the Judiciary Act of 1789. So, this goes to court. And we get the decision of Marbury v. Madison. Marshall, speaking for the unanimous court, because that's what he did, ruled that the court lacked jurisdiction. So at that point, now first of all, Marshall should have recused himself from this case because he was the idiotic Secretary of State who forgot to deliver the appointment anyways. So he shouldn't have even been involved in this. But he says, well, look, this really isn't in our jurisdiction, so we can't hear the case anyways. But, however, because it's already here, guess what? We're going to say that Section 13 of the Judiciary Act, which authorized Marbury to issue this writ, is unconstitutional. A sue for the writ is unconstitutional. So here we have the first time that the Supreme Court will invalidate a federal law. This gives us the very famous phrase, judicial review. Now again, when Marshall was arguing in the Virginia Ratifying Convention for the Constitution, he said that this could happen. And so did Oliver Ellsworth, and so did other people. This can happen. This was brought up in Philadelphia in 1787. John Dickinson famously said, well, I don't think this is a very good idea. John Rutledge said the same thing. He said, look, if this is going to be the case, nobody's going to ratify this stupid document. But there were some others who thought, well, we need to, kind of have judicial review. It'd be a good idea. And generally, the people that were against it were from states that didn't have it. The people that were for it were from states that had it. So here's John Marshall stepping in and saying, I realize it doesn't say in the Constitution where I can do this, but I'm going to do it anyways. Because this is what I said was going to happen. So there's nothing in the Constitution that says judicial review is constitutional. That's a power of the Supreme Court, but Marshall takes it on himself. Now, the fallout is interesting here. Marshall did, again, what many of the founding generation feared, and many in the founding generation supported. He used the court to strike a federal law. It's a federal law, though, not a state law. But there was no clear consensus on the issue. This also, though, was a clear challenge to the Virginia-Kentucky resolutions of 1798. Because what Jefferson and Madison said in those is that the state is the final arbiter. The state can act as a hedge. The state can block federal law. The state can declare federal law unconstitutional. Marshall's saying, no, not really. The federal government's the one that can do that. And so Jefferson and Madison, you're wrong. Now, one thing that's interesting going on in this Jefferson administration, the Democratic Republicans are going after these Federalist judges like crazy. And in fact, they had actually begun impeachment proceedings and impeached a federal judge, Chase. And Marshall was generally scared at this point that he was going to be impeached because the idea was that if a Supreme Court justice used his partisanship, or a federal judge was partisan on the bench, that was abusing their powers. That was doing something that they shouldn't do. They had to be impartial. So if they were doing that, if they're acting in a partisan manner, that was grounds for impeachment. That's how the issue was actually brought up. This was disbehaving. This was not good behavior. That's how the issue was actually sold to the states. You could get rid of these judges. Well, when Chase is not found guilty, Marshall knows he can do whatever he wants. He can be as partisan as he wants to be on the bench. He can go out and stick his finger at the Democratic Republicans and say, you guys are bad. You're terrorists, and I'm going to knock down all your legislation. He can do it because he's not going to be impeached. This is how crazy this got. Now, Jefferson actually wrote, this case of Marbury and Madison is continually cited by bench and bar as if were settled law, without any animadversion on its being merely an arbiter dissertation of the Chief Justice. What he's saying there is that this is the Chief Justice ruminating, look, this law is not really a good law, and so it's unconstitutional. It's ruminations of the Chief Justice. Well, I'm saying it's unconstitutional, so it's unconstitutional. He's going beyond the authority here. By saying we have no jurisdiction, it should have stopped there. That should have been it. But it didn't stop there, so it wasn't it. And now John Marshall is creating a precedent that every court can follow. Now, it must be noted that the Supreme Court did not declare another law unconstitutional for 50 years. But here in the modern era, this happens over and over and over again. Now, I'm talking federal law. Now, state law is another issue. John Marshall's going to go after those. But federal law, he leaves those alone because, most of the time he's got these good nationalists in power, so they're going to pass laws that he likes anyways. No big deal. But the states now, he's going to go after the states because those evil, rascally states often have Democratic Republicans in charge, and those terrorists out there. You got to get rid of those people. This brings us to the very famous case of Fletcher v. Peck, 1810. Now, what happens here is this is a really interesting case. The state of Georgia was bribed to sell by a number of wealthy individuals. They were bribed to give contracts to land called the Yazoo lands. These are great lands just west of Georgia. And basically what happens here is because of the bribery, they sign these contracts. And everybody in Georgia finds out about it. You got these bribe legislatures. A lot of the Northerners are coming into Georgia and doing this. And so when the state legislature turns over and the governor turns over, they repeal these things. They say, you know what? These contracts were made by a bribe legislature. We're not going to follow them. We're going to break these contracts, and they're no longer valid. Well, the contract holders will sue and say you can't do that. And the case will go to the Supreme Court. And John Marshall will say, you know what? You're right. The state of Georgia cannot revoke these contracts. So what he is doing here, first of all, he's going after Article 1, Section 10. Okay, but what he's also doing is saying, this state law that you revoke these contracts is unconstitutional. So now he's declared a state law unconstitutional. Oops. He swore in Virginia that they would never do that. The federal court would never trump the state courts. We'd never have this kind of problem. We'd never go out there and declare a state law unconstitutional. Here he did. This is why John Randolph of Roanoke would go in and point his little bony finger at Federalists and say, Yazoo. Very funny. Because he understood what was going on here. This was the federal government coming in and knocking down a state law. This was corruption at its peak. Corruption to get these contracts in the first place, and now John Marshall corrupt on the bench, saying, who cares if these things were corrupt? Who cares if these contracts were just horrible? You signed them. You gotta honor them. And the state legislature can't revoke those contracts. Once they're signed, they can't do that. So this validated corruption. and saved, of course, some Federalist money because these were Federalists who were getting rich on these things. It validated corruption. This is how horrible it is. And, of course, you have James Jackson, who Clyde Wilson in our Forgotten Conservatives in American History wrote a wonderful chapter about. He's one of the guys in Georgia that's working against this thing. He's a hero in the state of Georgia because he's working against the Yazoo claims. And then you have John Marshall saying, so what? I don't care about this. You sign those contracts, we're going to save your money, Federalists, and state of Georgia, you can't do this. So he's knocking down a state law, something he said he would never happen. Here's the greatest fear of the court system now being realized that, my gosh, we've got a situation where the federal government now, the Supreme Court, is going to go out there and declare state laws unconstitutional. This is horrible. Because now, again, what happens is, we generally do this all the time. You can go right from a state to appeal it right to a federal court. You don't have to go through the state court system anymore. Just appeal right to the federal courts. State courts go right to the federal courts. I mean, so the state courts, if the federal government deems it worthy of their approval to actually hear a case, they can hear state law all the time. You have to answer the question. Well, first of all, how are these 9 judges even attached to a state court system? How are they familiar with the law of the state of Georgia or the state of Alabama or the state of California or the state of Colorado or the state of Maine, state of Hawaii? Well, they're not. But because we think that the federal court is the be-all, end-all, the final backstop of everything, these are the guys that are these 9 judges. These are the supreme deities up there in their black robes. They can make all kinds of decisions. I mean, this is what people think. This is how horrible this decision turns out to be for the future of America. It all starts here, Fletcher v. Peck. And it's a very bad precedent, but this is what we get. So, in summary, the Marshall's early stamp on the federal bench made it clear that the Supreme Court in the future would again be this final arbiter, not only of federal legislation, but also state legislation. So the state courts then become subservient. And this is the great travesty of the Marshall Court. Had the ratifying conventions understood this was going to happen, I can guarantee you they would not have ratified the Constitution. So that great sales job of 1787 and 1788, keep referring back to it, those used car salesmen out there selling you a lemon for $5,000 and saying if you get a 2-year warranty, we'll take care of it. That's the Bill of Rights. The Bill of Rights is the 2-year warranty on the deal. But you got a lemon that's going to break down after 2 years. Hey, there it is. These guys are causing all kinds of problems. These duplicitous liars like Marshall and Hamilton and Wilson and people like that. I mean, this is how horrible it got. Marshall, again, was seeking to destroy Jacobinism in the states, and he favored national supremacy, aggressive nationalism. And that's what this is all about. It's about consolidating power, centralizing power. There's no other way to describe it. John Marshall is a scoundrel. He's one of my least favorite people in American history. There's nothing really good about John Marshall. I can find something good about a lot of people in American history that I don't like in particular, but there's always something redeeming about them. I guess the only redeeming thing you can say about John Marshall, he did serve in the American War for Independence, but that's about it. I mean, really, Marshall is a disaster on the bench, and it's because of John Marshall codifying Alexander Hamilton that we have all the problems we have today. So, of course, Dr. Gusman is going to get into some of these other Marshall cases, which are just as terrible, McCulloch v. Maryland being foremost among them. But, Marshall is a real problem you have to deal with. 34 years on the bench, giving us his interpretation of the Constitution, and everyone just goes out there. Again, they read Story, which is John Marshall light. They look at the Federalist Papers and look at, Alexander Hamilton and Marshall and what they're saying, and that becomes the Constitution, which is terrible because that's not the Constitution, particularly not the Constitution as ratified. Okay, hope you catch us again next time, and Dr. Gusman's lecture will pick up on this, the next presentation on the Marshall Court, and I hope you enjoy that one, and I'll see you in a few presentations when we start getting into some of the other issues of the antebellum period.